Hey everybody, there's a lot of discussion about a recent decision, a court case that said, federal judge says, hey, Donald Trump does not have the right to block his critics on Twitter, his followers, okay? He's got, I think, 52 million of them. And a number of people have rejoiced at this and said, oh, this means that no public official can block anyone for any reason on Twitter. So some elected officials have complied and unblocked people that they previously blocked. Others have been asked by other people to unblock. You get the idea, right? I'm not a Donald Trump supporter. I'm a Democrat. But what's happened is that the unpopularity of the president is so great that a case that arguably should have went in favor of the defendant in this instance went for the plaintiff. Let me explain in a very non-technical way, okay? What the case decision, the judge's analysis and final opinion forgot was the existence of states' cyber harassment laws. It skipped over thousands of pages of case law that have to do with that, and something called the limited purpose public figure. Here's the problem, all right? Even a public official has the right, the constitutional right in the United States of life, liberty, and the pursuit of happiness. That doesn't mean the judge's decision with respect to President Trump's tweets that an elected official or public official has to sit there and basically take anything a troll says, even if the public official, especially if the public official determines what is being brought to that person as emotionally harmful to them, as intended malice, okay? And you and I both know there are people who set up Twitter accounts specifically to cause emotional harm to someone. The 1974 Gertz case gave states the opportunity and the right to establish their own specific laws with respect to defamation and how that should be handled with respect to a public official. It also left some wiggle room as to, what a public official is and how that should be determined, or what the punishment should be on they left that on a state-by-state basis. But the Gertz versus Robert Welch case, one big problem. Because it happened in 1974, it predates the existence of the internet. And with the internet, we've had among other things, the development of the term limited purpose public figure or public person. And we've had a number of cases, like, for example, the famous skank blogger case, where a woman, a model who was called a skank by a blogger, had the right to be told who that person was so she could sue them for defamation of character. The simple fact of the matter is the ruling the judge made, this summary judgment, was done without hard analysis of evidence, without witnesses being brought, without an existence of a trial by jury, okay? And therefore, in my opinion, it is a ripe target for appeal, a successful appeal. And the reason is that I know, for example, states like North Carolina have cyber harassment laws that have been attacked by First Amendment advocates. I get that. But even in the instance of those cases where those attacks have been administered, the courts have left open wiggle room for those scenarios where public officials or anyone has been the target of what could be proved as actual malice. So I propose that in the case of Twitter, we can see or determine what actual malice is by a combination of the response of the person that's receiving the tweets and the reaction of those who are observing those tweets being sent. If it's the decision of the person receiving the tweets, the target, to block, then in some kind of way they believe they're being harmed. Again, they have the right to life, liberty, and the pursuit of happiness. It doesn't matter how you feel about them. Let me give you another example within that. The very recent case of Jennifer Schulte, Barbecue Becky, the focus of the Oakland barbecue incident. Are we to say that anyone has the right to just simply make her take any kind of criticism or worse, malice from the public? No. Regardless of how we feel about what she did, as an American citizen or as a person in America, she has the right, the constitutional right, not to have that forced down her throat. That's essentially what, or how the public is interpreting the judge's decision. And that's why it should be challenged. This isn't a matter of saving Donald Trump or anything like that. But again, the president is just that, the president of the United States, first of all, who's deserving of respect, an American citizen, obviously, and under the umbrella of protection of the Constitution, and should be. No one should argue that. It's disappointing we've gotten to this point to begin with, but that's another story. We need a return to sanity of argument with respect to online decorum and online treatment of people. We need solid, not just solid cyber harassment laws, but we need for First Amendment advocates to work to protect them as well.